Abortion advocates are now fighting to keep the medical procedure legal here in Georgia, and they have 3 weeks to plead their case. A restrictive abortion ban passed in the state in 2019 has been upheld in courts for 3 years now. 11 Alive's Caitlin Ross explains how now the Attorney General is asking the court to enforce the so-called heartbeat law now that the Supreme Court overturned Roe v. Wade.
Abortion advocates are pleading their case to the 11th Circuit, trying to keep the medical procedure safe, legal, and accessible in the state. A federal court has given them 21 days to argue why the judge should keep the so-called heartbeat bill blocked in the state. The state of Georgia is suing to enact that law, which passed the legislature and was signed by the governor in 2019. Right now, people in Georgia have access to abortion care until 20 weeks of pregnancy. There are 13 clinics that provide that medical procedure in the state. But if HB 481 becomes law, abortion will be banned as soon as a fetal heartbeat is detected. That can be as early as 6 weeks of pregnancy. The exceptions are rape, incest, harm to the mother, or if the fetus is not viable. Experts say they expect the ban will be allowed, and as written, goes further than the case the Supreme Court decided.
The Dobbs case that went to the Supreme Court was based on a 15-week ban, which obviously is in contravention of Roe. But here in Georgia, we're looking at a 6-week ban. And so it will be very different than Mississippi, and it will be in effect virtually immediately.
Planned Parenthood says they are still fighting to keep the medical procedure legal and say their doors will remain open to support people in Georgia no matter what comes next.
All right, thanks a lot, Caitlin.